Welcome to the Claims Underground podcast with your hosts, Corey Locke and Troy Willis, where we help policyholders just like you understand your policy and how to navigate through an insurance claim. We advocate for homeowners as well as businesses when insurance companies won't pay. So if you're tired of getting the runaround and ready to find out what's really going on, then let's get down to business and learn from the insurance claims experts, Corey Locke and Troy Willis.
Good afternoon. Welcome back to Claims Underground. Today we have a special host on our show today. His name is Ivo Labar. He's an attorney at law. I want to start by introducing myself today as usual. My name is Troy Willis. I am a licensed public adjuster. I am certified in IRCRC and different certifications. I also am a retired builder, expert witness, and also been in the industry for more than 30 years. My co-host here is Corey Locke, who has an impeccable resume as well. He's going to share, and then we're going to introduce Ivo Labar and give his credentials. Corey, take the floor.
Hey, welcome back. This is Corey Locke. 35 years now as an insurance adjuster, 30 years as a property estimator, triple mastered IICRC, ACAC smoke and fire expert, and also qualified expert witness. And we're so happy to have Ivo here today. Ivo Labar, we know Ivo, we work with him quite extensively. And Ivo, can you please just introduce yourself to our audience?
Well, how are you? My name is Ivo Labar. I'm an attorney in San Francisco, California. My law firm is Sawyer and Labar. We've been operating for 23 years. We have offices in Los Angeles and San Francisco Bay Area. We handle a great deal of insurance coverage, policyholder work across the state and across the country. I'm happy to be here today to answer questions and discuss these topics with you fellows.
Thank you. Well, what are our topics today that we bring to the table? Because a lot of our listeners would really like to know. And I want to start out by thanking a lot of our new subscribers that's joined on. We've actually hit the threshold of 4,000 subscribers on the TikTok, and we're over 2,100 subscribers on YouTube. So we want to keep everybody posted. And we are following everyone's comments, and we definitely comment back on what you have to say. So thank you again. So back to our question, the overview of an attorney's role in the claims adjusting process. Many people that have claim losses don't know what to do, Ivo. So what they do is they normally don't know what a public adjuster is. They call an attorney. And a lot of times the attorneys will say, hey, your claim's not ready right now for me to take on, and they don't really know quite what that means unless an attorney kind of refers them over to public adjusters that can help them get the case in orders. What would you want to express and let our viewers know regarding what this process is so we can help them educate them a lot better?
Well, thank you, Troy. The most important point and first point is that there are only 2 licensed professionals in the state of California that by law are permitted to represent policyholders or insureds in the claims adjusting process with the carrier. Those 2 types of professionals are, number 1, public adjusters, and number 2, attorneys. No one else is allowed by law to represent the interests of the policyholder. Your insurance broker can't do it. The insurance adjuster from the carrier can't do it. Your contractor is not legally allowed to do it. No one other than attorneys and public adjusters are allowed to represent the interests of insureds, and that's by statute in the state of California, and that's been the law for decades. So with that sort of preface, it's important to see what each of these professionals, what role they fill in the claims adjusting process. Now, hopefully, an insured doesn't have any trouble in the claims adjusting process, and they're able to interact cooperatively with their insurer and get their claim resolved in an effective way without the aid of a licensed professional like a public adjuster or an attorney. But in the event the insured does encounter some trouble, then they need to turn to a public adjuster and or an attorney. Now, what role do both these two professionals play in this process? A public adjuster should be looked at to assist in the claim really at the outset when difficulties arise or when the insured simply needs help with the claim because they're overwhelmed with the amount of document requests or just don't want to deal with the claim on a day-to-day basis. The public adjuster is the person who will ultimately put together the claim for the building replacement, personal property, additional living expenses, temporary housing, and any other coverages that are afforded by the policy. That is a critical and fundamental function in the claims process because it's the insured's burden to put the claim together. And a public adjuster is the primary person who can help with that. So what role does the attorney play? The attorney should come in to defend the insured's legal rights when those legal rights are at risk or at risk of being put at issue. The attorney's role is really to come in when the insurance carrier has either denied the claim and simply said they're not going to pay the claim or some portion of the claim. So when you have a denial, you should look at contacting an attorney to see whether or not that denial is appropriate or otherwise could be reversed. Or you should also speak with an attorney if the public adjuster or the insured himself has reached a point on the claim where there's significant valuation differences between what the insurer wants to pay and what the insured thinks they're owed. So where you either have a denial or a large difference in valuation, perhaps an attorney is in aid, especially in the second situation where the public adjuster has sort of reached the end of the road with the insurance company. And lastly, the third time you may want to consider contacting an attorney during the claims process is if the insurance company seeks additional information or requests testimony from the insured in the form of a recorded statement or an examination under oath. And what is that? Every insurance policy, and this dates back to hundreds of years ago when maritime insurance first developed and the Lloyd's of London exchanges in the UK. And of course, that body of insurance law has been transported to America over the years and codified in each state. But there's always been a provision in insurance policies allowing the insurance company to examine the insured and ask them questions under oath to verify whether or not their claim is legitimate or should be paid. And in the event that an insured or the insured's representative, the public adjuster, is contacted regarding an examination under oath or any other kind of recorded statement, I would highly recommend that the insured seek out counsel to defend their interest in that proceeding. And those proceedings are not legal proceedings, they're contractual in nature, but they're governed by rules set forth in the California Insurance Code. And it's very important that an insured have representation during that process to maintain their claim integrity and to make sure their rights are preserved and protected. Troy?
Wow, that's so well said. And I hope that actually helps viewers, especially when they sitting down there and, like you say, looking at a denial or a partial denial, and they still don't quite understand what to do. And even when I speak to some of my clients or we speak to them, just what you just covered, I had this conversation with one yesterday. We set a file up for two reasons: to advocate for their behalf, as well as to actually set it up for litigation to go to an attorney in case it needs to go that direction. So, you just gave a clarification that I'm hoping they actually watching this one because it clarifies it again even more in specifics. In this process of someone bringing you on board, let's say it comes to the point they bring you on board, how will it work between you as the attorney and still having a public adjuster on board?
Sure. In the event that an attorney is brought on board, there's two roles the attorney can initially serve. One is to simply initiate litigation in the traditional court process for a breach of contract, potentially bad faith claims handling. But the case isn't ripe for that yet, or it's just not the appropriate time for whatever reason, not litigation. The attorney can sort of serve in an advisory role and advise the public adjuster on any necessary steps required before a lawsuit could be brought, assist in evaluating other coverage or coverage interpretations of the policy to the public adjuster and the insurer advocating themselves with the insurance company to have the insurance company change their position. The analogy I always give pre-litigation and during the claims adjusting process, whenever I'm speaking to a layman on these topics or layperson on these topics, is I explain that during the claims adjusting process, the insurance company is the judge, the jury, and in some senses the executioner if they give you a denial. They set the ground rules for the claims adjusting process. Now, those ground rules that govern the claims adjusting process should be informed by state law and regulation and the policy itself, but they not always are because insurance companies sometimes don't follow their own rules. But the important thing is the insurance company is the one making the decisions during this claims adjusting process and ultimately rendering a final decision in the claims adjusting process. So it's important to create a record during that process that best advocates for the insured's position under the policy in their claim. And an attorney, of course, with the legal training that they have, can inform the public adjuster and the insured during that process of how to best create that record. Now, I continue on with that analogy because it makes it sound like all the power is in the insurance company's hands. And it is during the claims adjusting process because they're the ones that hold the purse strings and ultimately decide whether or not the insured is getting paid and the benefits that they're owed. But that changes when you move the claim from the claims adjusting process into a court case in the legal arena where a complaint's filed and the insured is the plaintiff and the insurance company is the defendant. At that stage, once you're in litigation in the court process, then no longer is the insurance company in charge. At that point, a judge and or a jury will eventually make a decision regarding whether or not the insurance company's actions during the claims adjusting process were acceptable under the policy and whether or not they're acceptable under state law as codified in the insurance code and the California Code of Regulations. So that's basically my view of how the attorney can assist in both of these areas.
Well said.
Evo, I had a question on that. I know that we had a slowdown with filings due to pandemic. Are we now starting to see court cases being assigned trial dates now here, at least in California?
Yeah, while jury trials were suspended in large part during the lockdown period during COVID, most of those provisions have been released and cases are being filed, processed, and headed to trial. And we are back in the trial game again in virtually every county that we're doing business in California. So things have opened up, and if you filed a court case today, I would anticipate in most counties in California, you'd get a trial date within 18 months of that filing, and somewhere along the way, there'd be multiple opportunities to resolve the case by settlement or motion practice potentially, because it is important to keep in mind, very few cases do in fact go to trial. Some of the last statistics I saw said that about 95% of cases were resolved by settlement or otherwise before trial. So you're looking at a time frame of about 12 to 18 months once you file the case to get to a point where the case will get resolved.
But not, like you said, not every case gets filed as a suit. Some are handled in pre-litigation, which you and I have been, and Troy, and have been involved with. Pre-litigation is something that probably not everyone understands. They understand that the idea of a lawsuit, but they're not understanding probably the idea of pre-litigation. Can you give us a little explanation of pre-litigation?
Sure. I think that when an insured has a claim with an insurance company and the insured believes that they're being mistreated or they believe they're not getting all the benefits due under the policy, their role really is to advocate for themselves and attempt to change the insurance company's mind. Now, that can be a very tall order to fill, given that the typical insured is a layperson and doesn't have the background in either claims adjusting or the law to get the insured or the insurer to change their mind. However, if a public adjuster and or an attorney get involved, they can basically set the stage and say, these are all the contractual provisions that you're violating, insurance company, or these are the state laws and regulations you're violating, and these are the reasons why you need to pay the claim. Now, that record can be created, as we talked about creating, prior to, say, simply just filing suit. So there could be a period of a couple of months where you try and get things resolved pre-litigation before you actually file a traditional lawsuit. And there's another added provision. I mentioned that every insurance policy in the state has an examination under oath provision where the insurer can demand before a lawsuit to examine and cross-examine an insured and obtain their sworn testimony. And that's called the examination under oath provision. There's another provision that's part of the standard form insurance contract that's known as the appraisal provision. Appraisal is a form of arbitration. And what the appraisal provision in standard insurance policies, property policies, provides is that there's a dispute over valuation, how much it'll cost to rebuild the building, what's the value of your personal property. Any type of valuation dispute, that may be ripe for appraisal, which is a contractual proceeding, not a legal proceeding, but a contractual proceeding where each side appoints appraisers to advocate for them. Sometimes these appraisers are attorneys, sometimes they're not. And if they can't reach a decision, then a third individual known as an umpire resolves the dispute and sets forth the value of the loss. And that is an avenue that is frequently used in insurance policies when there's a dispute over valuation. Unfortunately, while this particular procedure was originally viewed as a simple and low-cost method of resolving valuation disputes between insurers and insureds, over time, like everything, it became more complicated, more cumbersome, and more expensive. And now appraisals can be just as expensive as litigation. So if there's an issue about whether or not you should appraise your case or file a lawsuit, it's always best to consult with a public adjuster and an attorney to see what merit each procedure could potentially have for the insured. Corey?
Yeah, with the appraisal that I've been involved with recently, it's almost like a mini trial. You're having both, the plaintiff attorney, defense attorney appearing in Zoom. They're cross-examining witnesses. You have the appraisal panel, one umpire, and then two appraisers. They're all sitting in Zoom for 8 hours, and it's all being presented as if you're in trial. They're recording it, of course, and it seems to be a far cry from the understanding that, okay, I'm going to go to appraisal. I'm going to hire my appraiser. The insurance company's going to hire their appraiser. If they do get to a disagreement, then we'll go and talk to an umpire. This seems to be like we're trying to, create mini trials and mini litigation with the appraisal that I just recently came into. Is this something that's becoming more commonplace, Evo?
It's certainly my career in the past 23 years. Appraisals have gone from what was a simple, straightforward process to increasingly complicated over the years. And what's become the most biggest impediment to appraisals being an effective remedy for policyholders is simply the cost. You have the insured is required to pay their own appraiser and split the cost of the umpire. And these expenses can be quite significant. And if your dispute's in the low six figures over the valuation, I've certainly seen cases where the appraisal proceedings themselves have ended up costing half as much or nearly as much as what was at issue. And this is simply out of reach of most policyholders and not an effective way to resolve these valuation disputes. And it's really a situation that cries out for legislative change. That's beyond all of our pay grade on this call, but it would be great if the legislature would do in the insurance context what they have done in the employment context, which is shift the burden and cost of arbitrations to the employer. And that would be a nice thing to have seen here, shift the burden and cost of appraisals to the insurance company. But that's a topic for another day.
We've had that, we've run that battle so many times around over here. And we totally agree with you about the process. Me and Corey both are certified umpires and certified appraisers. And we know it's very costly to get what you need. And we don't really see that benefit many times for our customers. And, we've had this discussion more times than I can tell you about, why we don't like the appraisal process because of just what you just mentioned in cost. The question that comes about, though, when it comes to the appraisal process for me is that, what choice do an insured has when they caught between, again, we have a low figure amount due and say $50,000 they don't want to pay. And that's a pretty big delta. It's not big enough for an attorney to take on. The appraisal is going to cost them, almost $15,000, $20,000 between the appraiser and the umpire. What resources do these people have?
There are few and far between, unfortunately, but one significant resource in that arena for what we would call modest dollar amounts, but still may be very important to an individual person, particularly someone on fixed income person. When you're talking about that just don't justify appraisal or litigation, one significant resource is the California Department of Insurance. They do have a mediation program and a complaint process program by which you can make complaints and hopefully have the DOI initiate a process that to aid the insured. Again, the DOI is an agency that is a great deal of insurance companies and has a full plate. I'm not, but that program is something that is available in that very difficult rock and a hard place situation you just described, Troy. Another thing I would mention, though, for low valuation issues where there's a modest amount of money in dispute, I would still urge that insured to contact an attorney and just get their take on the situation, because I've handled a number of class actions against insurance companies over the years that individually, on an individual basis, were not significant enough to bring legal action. But where an insurance company is implementing a policy or a procedure against a whole group of policyholders and it's illegal as a matter of law or it violates a regulation, that could be a situation where a class action lawsuit is appropriate to try and remedy that situation. And I've handled a number of those over the years, particularly related to amounts that insurance company has wrongfully depreciated against policyholders. And we set some real groundbreaking law in that regard a number of years ago. But that's an area too, and a potential resources. So I would just always recommend that an insured, no matter what the dollar amount, contact an attorney to see if there's something potentially there or if their rights are being violated in some other way that may have a resource.
Okay. Well, I have one more. If Corey has something after this, I have one more question for you. One of the things that we see quite often now is our seniors and our disabled being taken advantage of. I just took on a recent client who is disabled 100%. And just the emails that I'm seeing between the carrier and him is totally out of order. I mean, it's almost like they truly picking with his mental. You can truly see that they're doing this intentional just by some of the ways they approaching his questions, and it doesn't help the situation. And one of the things we realize is doing this that disabled and elders have rights under for insurance in the state of California that's a little bit different than us as typical people. Could you explain that, what those rights are for disabled and elders?
Sure. Just at a very high level, there are statutory schemes or statutory code laws that protect senior citizens and disabled people from discrimination in the handling of insurance claims or other wrongful conduct. These laws, some of them provide for additional damages and attorney's fees in the event that you can prove a violation of these laws. It's another sort of quiver, arrow in your quiver when you're examining a potential claim and seeing what remedies are available. This is actually a very good point to note about the attorney's fees, because in your traditional insurance contract litigation, while there is an exception, for the most part, each side bears their own fees. And it's the unusual situation where an insurance company has to pay fees to the insured after successful litigation. Those types of cases are quite rare. There is a very limited exception, as I say, but they're quite rare. And most of the time, people have to bear the burden of their own fees. But if you're in a protected class, such as disabled or elderly, there may be situations where the elements of elder abuse, for example, are fulfilled, and that could provide a remedy such as attorney's fees in addition to additional damages. Corey?
Yeah, we've had quite a few of these that people come on and they're more than 65 years of age, which technically makes them an elder, or they're partially disabled or fully disabled, and it's something that we discuss with clients, but they're really kind of put off by the idea that they're going to go 18 months or 12 months into this process, even though we're telling them that there's light at the end of the tunnel. But as the three of us have talked over previously, we have successes here. It seems daunting to go up against an insurance company and all the people that say no to you, but at the end of the day, we can also count on our hands that we are successful, and the successes are based upon building a record, building the correspondences, the record, and proving the loss. And I'm seeing quite a bit of conversation that we're seeing online uh, with the new adjusters coming on, and they're basically very dismissive of what they classify as inflated estimating. The one thing I was going to ask you, Evo, is there a difference between lowball estimating and inflated estimating? And so what they're basically trying to accuse public adjusters of doing, of overinflating the estimates, and yet no one's talking about the lowball estimates that we constantly see from the carrier standpoint. And I think that I'd like to hear your take on what's when you see a public adjuster's estimate, is it something that you're concerned about, that they're overinflating the estimate?
Well, I wouldn't. First of all, if I'm examining the insured's claim and their estimates in the claim, I'm always going to rely on competent professionals. I'm not a builder myself. I'm not an expert. No attorney is. Very few attorneys are holding a pen in one hand and a hammer and nails in the other. Very few people have. I'm sorry. Very few attorneys have that sort of day-to-day construction knowledge to know what appropriate estimates are for the region, for the time period in question, for the type of structures being built. You have to rely on your experts, and in this case, the public adjuster is the expert, and as competent licensed professionals, they're using the best resources along with whatever vendors they're working with, perhaps the insured's general contractor, et cetera, to determine the appropriate pricing. Claims adjusting shouldn't be a game where one side asks for too much money and the other side offers too little, and there's just endless negotiation. That's the opposite of the way the process should work. Both sides should put forth good faith estimates, and they should be pretty close together because we're working from the same information. And so I always urge people to not overreach, to not exaggerate their claims. That's a tremendous mistake. It's the number one killer for any claims adjusting process mistakes you could make, is to over exaggerate your claim.
Right.
So in short, the short answer to your question is I think everyone involved in the process, the carrier and the public adjusters and the insureds, should only be submitting valid, legitimate information based on reasonable, good faith sources that are contemporaneous. And if both sides are doing that, there shouldn't be this issue of large deltas between the claims. I mean, normally that can also arise from lack of information or understanding the true scope of the claim. Because if the insurance company doesn't have a true scope of the claim, how can they accurately estimate it? And we've seen this situation hundreds of times in our careers, thousands of times in our careers, where an insurance company is making an estimate for a structure based on a Google image map and some basic measurements without actually physically inspecting the home in detail, without actually surveying local prices, et cetera, et cetera. So with all of those things being said, you really just have to look at it on a case-by-case basis and say, it's easy to throw around pejoratives like lowballing or highballing, whatever you want to call it. But the reality is there's evidence out there that can prove it. So let's look at the real evidence.
Right. Thank you.
Well, I'd like to say thank you very much for joining us today. We have really appreciated having you on the show. We usually have a thought for today, and Corey's going to lead with that thought for today, and then we'll sign off, and we'll definitely have you back again for another show. So we'd like to all thank you for being on today. Corey, would you like to share that thought for today?
I think the thought for the day is always you got to secure your policy, read your policy, and ask the questions. If you're feeling that your claim is being undervalued, you're likely right. And the only way that you're really going to get to the true knowledge of your claim is to know your policy, ask the questions, and also secure the assistance of a professional that's going to put it together and present it in a way that the insurance company is going to have to make a decision on. Comes down to just that much.
Couldn't have said it better. Signing off, Troy Willis.
Corey Locke.
Ivo Labor. Thank you.
Thanks for listening to the Claims Underground podcast. We hope you enjoyed this segment. If you need more information on insurance policies, feel free to check out our website, www.claimsunderground.com. And remember, when the insurance companies won't pay, we're here to help. Until next time.